roll on. Every Sunday at 4 p.m. Central Time, we do bring in immigration updates. Along with us is a prominent immigration lawyer, Emily Newman. She's been practicing immigration law from 2005, and she's been a partner in the Reddy Newman and Brown. Emily, what do we have today to discuss? Mainly is if a person comes on B-2 visa, B-1 or B-2 visa, they're coming with one-way ticket to United States. Even though some of them have plans to return back, what are the dangers for the people who are coming into United States on B-1 and B-2 with only one-way ticket to United States without any return ticket to go back to their home country?
Yeah, you have to understand that just because you've been issued the visa at the consulate and it's stamped in your passport, that's only half the battle. You still have to prove to the officer at the port of entry at the airport that you meet all of the requirements for B-1 or B-2 visa. And the main one is that your stay in the U.S. is for a specific temporary period of time. And so if you are coming into the U.S. with a one-way ticket, no return ticket, that means you do not have any specific plans to stay temporarily and return back to your home country. The danger of that is you can actually be deported when you're at the airport, denied admission, and if they feel that you have misrepresented anything to the consulate to get the visa, and now you're coming in with different intentions because you don't have a return ticket, that can result in expedited removal, which is a very quick version of deportation, and that can cause a 5-year ban on you being able to return back to the U.S. And that visa will be canceled. So it's a very high risk of not being let into the country, being sent back to your home country, simply because you didn't have the proper documentation when you were traveling to the United States.
Emily, let's go to the live questions because the show, the TV9 show is more about live questions, having people call into show where they can ask questions. People who wants to call in and join us, the number to call is 833-882-8872. Let me repeat again, 833-882-8872. The first caller today will be caller ending with 9849. What do you have question for us? 9849. Caller ending with 9849.
Hi, Rahul. Hi, Emily. This is Siddharth speaking.
Mm-hmm. Go ahead with the question.
Yes, my priority date was 2014 October, and I got a green card when the date was current. But my question is, now my friends are forcing me to start a vaping store. You know, I've been following you, and I know you are discouraging non-immigrants to hold the cannabis stock. But this vaping store has, they don't sell cannabis directly in the Texas, but they sell this extract of a cannabis, you know, for the vaping purpose. Or do you think it's an issue when naturalization, if you get into such business, or
Emily, can you answer the question?
I have.
Yeah.
Yeah. So it's. Go ahead.
You go ahead, Emily. Sorry.
Mm-hmm. It boils down to whether those particular substances and business that is being sold are on the federal list of controlled substances. Off the top of my head, I don't know whether those particular types of substances are on the federal list of controlled substance. So even if the state of Texas allows that, you need to look at what the federal government says about it, and definitely get a very detailed opinion of that before you start anything. Even when you're a green card holder, you need to be a citizen before you can take certain steps with that. So you have to look into what substances exactly those are and whether they're on the federal list of controlled substances.
So Emily, let me ask you this question again. Let's say, for example, in Denver, marijuana is legal. So you mean to say that marijuana selling is legal, marijuana buying is legal. So green card holders cannot do it? Is that what you meant to say, Emily?
Correct. Yes. Anything that, although it's legal in the state, there is still a federal national law that says that it is a violation of law to deal with any kind of controlled substance, and marijuana is on that list of controlled substance. So even if it's legal in the state, it's not legal for federal purposes, which means it can cause great danger to your immigration if you're a non-immigrant or green card holder.
Okay. We'll go to the next caller. The next caller ending with 549. You have any question for Emily? Caller ending with 549.
Hello.
Yes, go ahead.
Yeah,
Ma'am,
thank
go
you for taking my call.
Mhm.
Can you hear me?
Yes, we can. Go ahead, ma'am.
Hello.
Yes, we can
Yeah.
hear you. Go ahead, ma'am.
Actually, we have filed EAD and AP along with I-485 filing in EB2 category in the year 2022. But we received only EAD, not AP. So ESA sent us a letter saying that the case was closed as we received benefits through others. So actually we received EAD AP combo card through EB3 category in year 2020. That's the reason ESAS didn't issue AP in EB2 category. So my question is what document I need to provide along I-131 form for previous issued AP, as we were never issued AP in EB2 category.
So let me understand the question. You filed EB3 485 along with the 765 and I-131, and you filed EB2 485, 765 and I-131. The EB3 one, advance parole got approved, but the EB2, which you filed later on, got denied, saying that previously you got the benefit, you got the advance parole approval. Let me, just to clarify the question a little bit more, when is the advance parole for the EB3 expiring though?
Last year, December.
Okay. Emily, can you tell what's the best option for her to do right now?
Yeah, at this point, you can refile the I-131. You only need to submit your I-485 receipt notice as proof that you have a 485 pending. You don't need to submit anything related to the previous AP since it's already expired and you didn't get the second one that you filed for. So you can just go ahead and refile it. We do see that happen from time to time when you already have an approved AP through one I-140 and I-485, and then for people that have multiple 485s, sometimes they'll approve the second AP, so you have two at the same time, and sometimes they don't, and they just deny it or administratively close it. So no problem with that. You can just refile it.
Emily, this time, how long she is going to get the advance parole approval? I heard there are some changes in the advance parole approval timings and EAD approval timings now.
Yeah, once she finally gets it, it should be valid for 5 years, which is good news, but it is still taking a year to process those applications.
You have any more question, ma'am?
Yeah, I have another question. For my family, can we put all EAD AP forms in a single package, or do we need to send separate packages or envelopes?
Emily?
You can put them all together in one envelope is fine. Just make sure they're separated within that one envelope.
I'll go to the next call. I'll go to the next caller. 1221. You have any question for us? Caller ending with 1221. You have any question for us? For those people who are waiting, who wants to reach us,
Yes,
you
sir.
can
you
call
hear
us
me?
at 833-882-8872. Yes, go ahead, ma'am, with your question.
Hi. So in 2008, when I was in H4, right now what happening is we are applying for our I-485 EAD, and in 2008, when my H4 got approved, right now while providing all the documentation, we are missing the approval notice for H4 from 2008, but we do have the applied receipt. So will that work, or we should try to get the approval notice or try to get that document?
Emily?
Have you traveled outside the country since 2008?
No.
So you've been in the U.S. When did you enter the U.S. last?
like most recently we entered in 2021.
Okay, so you have traveled outside the U.S. since you came in on H-4 in 2008. It's fine to use that receipt notice. You can enter the case number into the USCIS.gov case status website to print out the current status, which is likely going to say in 2008 we approved this I-539. So you put that together with the receipt notice, you'll be fine.
Okay. Yeah.
Okay.
That answers my question, ma'am. Thank you very much.
Thank you. We'll go to the next caller. Caller ending with 7441.
Hello.
Yes, go ahead, ma'am, with your question.
Hi. I have a question on the H4 EAD. So my wife's on H4 EAD, and she had a passport with the name written in just the given name column. So all the documents in US were like starting with FNU followed by her name.
Mm-hmm.
We decided to correct it, and she applied for a new passport, which she has received now, and we traveled to India, and her stamping is also showing correctly on the passport with first name and last name. Now we want to get the other things corrected, like the Social Security and the driver's license and everything else. So we went to the Social Security office, and they said you need to get the EAD document updated. So the current one that we have is valid until the end of next year. I'm just trying to understand how we can we submit a new application to get it renewed or corrected? How do we deal with this?
Emily, I'm just thinking, is it if he just gets a name change from court, is that better, or getting the EAD is better, Emily?
Well, I would ask, is it super important right now to get the SSN and driver's license updated? I would say probably not. Just wait until it's time to file your next EAD, get it done at that point, then take care of the Social Security number, then the driver's license. There's nothing really urgent, at least in most situations, unless you've got something going on that I'm not aware of. But for most people, you don't have to do everything all at once. But you could file the I-765 for a replacement EAD card for that name change. The only problem with the replacement is it's going to expire at the same time, so you're not really getting the benefit of an extension. So for that reason, you could wait until it's time to file the renewal, submit the updated documents at that point, and then once you get that card, take care of the Social Security number later.
Okay.
You have it? You have any more questions, sir?
I have. Can I ask another one?
Sure.
Okay. So this one's about me. So I'm on H1, and I have a priority date of September 2015 in EB2.
Mm-hmm.
I've been exploring EB1A, and one of the questions that I had on EB1A is, let's say if I have switched, I would not say switch jobs, but let's say switch titles and technology. I'm working on, let's say, a totally different thing on IT, within IT though. Let's say one was related to software development. This one is now related to more cybersecurity. And I'm kind of into a managerial role as well. Can those things, all these like varied experience, be counted as an extraordinary ability?
Emily?
So generally, USCIS wants you to pick the field that you are claiming the extraordinary ability in. And so it might be difficult for you to partly qualify under your software development skills and background, and then partly qualify under the cybersecurity side of things. I think you've got to pick one, and that's the strongest one, and build the case around that. Depending on how you build that case, and depending on how you frame your field of endeavor, what your area of expertise is, that will determine what you have to show in terms of your past employment history and experience, contributions to the field. So if you have been in software development and you're just now moving into cybersecurity, you may not be an expert in cybersecurity yet. That's what they're looking for, is do you have that expertise? Are you at the top of that field? So you may have to rely more on the software development side than the newer area, if that makes sense.
Emily, being a manager, is that one of the qualification for the extraordinary ability?
No, not at all. It doesn't make a difference at all.
Okay. So it's extraordinary ability. How many you have to qualify? What are the, I know there are 10 things. How many you have to qualify out of those 10 things, Emily?
Yeah, you've got to qualify with at least 3 of the 10 criteria. On top of that, though, just meeting 3 is not enough. You have to show that they do a kind of final merits determination after you've just met the bare minimum of the 3 to see if looking at the totality of the evidence, all of the circumstances, have you risen to the top % of your field such that you have that extraordinary ability. So just meeting the 3 out of the 10 is generally not enough. You've got to show above and beyond that.
We'll go to the next caller, Emily. The next caller is ending with 888. Do you have any questions for us? Phone number ending with 888. In the meantime, let me ask you some of the questions unless he asks any questions, Emily. Emily, now we see a lot of trend as the priority date is not moving, and Charlie from State Department has said that it's very unlikely that the priority date is going to move. A lot of people are trying this option of EB1A extraordinary ability, where out of the 10 qualifications you explained, they have to qualify for 3 of those qualifications. Which are the common 3 of those qualifications, which when you file for EB1A, which you see people try to hit?
I would say high salary is a very common one. That's pretty easy to show. You can look at DOL prevailing wages. You can look at private wage surveys to show in your area what is the typical salary and then what your salary is in comparison to that. Judge of the work of the others is also very common. That's typically in the academic sense for an EB1A. It would be if you are on a panel where you are looking at submissions for a journal, for example, and reviewing other writers' contributions to that journal. But it can also be in your work, in your, everyday life when you are at work. Maybe that's where, as a manager, you could argue that you are judging the work of your subordinates in that particular area of expertise. So you can judge the work that way. Beyond that, significant contributions to the field, typically through recommendation letters from past coworkers or from people that you have that are familiar with your work and can share how it has impacted the specific field that you're trying to qualify in. Those are probably the main criteria that most people try to hit.
And Emily, when you get an EB1 I-140 approval, can people port the date from EB2 to EB1?
Yes, and that's why so many people are trying to do this, because once you get into the EB1 category and you keep your old priority date, for a lot of people that date is current. So that's a big benefit of making that switch.
Caller ending with 7688. Do you have any question for us? 7688.
Yeah, hi. I'm Srinivas.
God, Srinivas.
So this is this question. Yeah, hi. So this question is like for my friend actually. So my friend has an DUI in 2016, but he never went to India. He's planning to go India in July. So for the visa stamping. So will it affect his dating for this visa if we go to India for the stamping? So I just want to know about this. So.
Yeah, so when he fills out the DS-160 application form, there is a question on there that asks, have you ever been convicted of a crime? Have you ever committed a crime? Have you ever been arrested? So a DUI is going to come under all of those. So he has to answer yes. He'll have to provide the information in the small box about when it was and what happened and what the outcome was. And then he's likely going to be called in for an interview rather than Dropbox if he had qualified for Dropbox. When he comes in for the interview, he's got to have all of the documents related to that arrest. So he needs the actual arrest report, all of the court documents to show how that was eventually disposed of or dismissed, or whether he served the sentence, or all of the outcome of that. got to have all of that documentation. And then because it was more than 5 years ago, it's not mandatory that they're going to have him do a panel physician to verify that he's not what they call a habitual drunkard. But they can still ask questions about that. So part of the interview, they're going to try to determine whether he has a drinking problem still. And if he does, they could refer him to a panel physician for a physician to decide whether he has a drinking problem and can be denied the visa for that. If they don't think he's got a drinking problem, it was just a one-time incident, and he's got all of the documents, then yes, he can still get the visa. It's just probably going to go into administrative processing or take longer than it normally would.
Emily, I'll ask you a question.
Oh.
You see the DUI people, for the audiences, DUI is people who have been arrested for driving under the influence of the alcohol. Emily, if 100 people have gone for stamping for DUI, how many people get the stamping for H-1B? How much percentage of the panel?
I would say probably 99% for people that it's a one-time incident. They don't actually have a drinking problem. They took care of all of the court things that they were supposed to do. They've moved on with their life. They're, a good person. I've not really seen people denied the visa for an old DUI.
Sir, you have any more questions for Emily?
No, I am good. So yeah, so that is the only one thing. Yeah, that is the only one record he has. After that, he doesn't have any record. So I think, I think he should be good then. So
sounds good.
Yeah, thanks for that. Yeah.
Emily, going to the topic that I was discussing on people trying to move to EB3, EB2 to EB1, one thing you covered is extraordinary ability, Emily. Why don't you explain how the EB1C works out, where people are trying to go outside the country, working for 1 year and come back and get the EB1C, and they can port the date from the EB2 to EB3, EB2 or EB3 to EB1. What is a typical? How do typically people get this EB1C approved and move their priority date from EB2 to EB1? What are the parameters for EB1C category? What should they be careful when they are moving outside the country and starting to work for 1 year and come back into the United States, Emily?
Yeah, the most common scenario is they're already working for a company that's a multinational company, meaning they have offices in the U.S. and they have offices outside the U.S., often in the person's home country. If the company is on board, the company can send the person to their home country to work for 1 year. But you have to make sure that that 1 year is in a managerial capacity. Just because they call you a manager doesn't necessarily mean your work is in a managerial capacity. There's two ways to show that you have managerial capacity. The most common one is that you actually have direct reports, subordinates who report to you, and you are managing those people, and you're spending at least 51% of your time managing these people. You have the ability to hire them, you can fire them, you can increase their pay, you can approve leaves, you have the ability to do their performance reviews, and you're giving them feedback, and you are at a high level within the organization or the team or the department that you are managing. That's the most common type of manager. And so if you're doing that 51% of the time, it can qualify you for the foreign position to potentially qualify an EB1C. There's also a functional manager position where you don't necessarily manage people, but there's an essential function of the company that you manage instead, and that you have a wide range of discretion over that particular function. You operate at a high level with that particular function. You're reporting to the president or the CEO or very top level executives on that particular function. But you have to show, if you're a functional manager, that you're not doing the function yourself. There are other people that are carrying out the day-to-day activities of the function. They may not directly report to you, but you have to show those other people that are actually carrying out the duties of the function. So all of that, if you can make sure that the foreign position meets either of those definitions, then if your U.S. position, after 1 year, you're being brought back to the U.S. and your U.S. position also qualifies as either a people manager or a functional manager, the company can file the EB-1C I-140. So, a lot of times I have people kind of ask, well, there's a job opening in my home country, in my company. I want to quit my U.S. job and go and take up this foreign job, but not ask anything about doing the EB-1C and hope when I come back later my company is going to be willing to do it. I definitely would not go with that route. You want to make sure before you invest the next year of your life outside the U.S. that the company is going to support the EB-1C, because if they're not supporting it, then what was the point of moving abroad? So you want to plan it out in advance, make sure your company is on board with it. And then you have to decide, how is it you're going to come back into the U.S.? For a lot of people, you can come back on H-1B. You don't necessarily have to switch over to L-1A in order to get the EB-1C. You might try to do the L-1A to see if you meet the requirements of the EB-1C before you go through the green card process and EB-1C. But since you only have to be out for 1 year, if you have an H-1B that's valid for the next 3 years, you could go out, work for 1 year, come back into the U.S. on H-1B, and then have the company still sponsor the EB-1C even though you're on H-1B.
We have a caller ending with 540. You have any question for us? 540. 540, you have any question for us? Oh, before
Hello.
yeah, go ahead with your question now.
Hello. Yeah,
Yes.
hi. I have a similar question, the one they asked for the DIU, but it's for a DV case. So what would the scenario be in case there's an existing DV case? A friend of mine is going through a similar situation.
DV, what is DV? Domestic violence.
Domestic violence.
Okay. Emily, if it's a domestic violence,
So for the stamping.
how different it is for a domestic violence as compared to the DUI, which is drunk under the influence of alcohol, Emily?
Yeah, definitely need to consult with a qualified immigration attorney personally on that, because domestic violence can, depending on the exact situation, be considered a crime involving moral turpitude, which is a fancy way of saying it's a crime that is against society. And we don't give people visas who commit crimes involving moral turpitude. It's a ground of inadmissibility. So the visa stamp can be denied. You can be denied entry at the port of entry. So before any kind of travel, if you've got that in your background, definitely contact a qualified immigration attorney who is in the state where the domestic violence issue happened, because they need to be familiar with that particular state's domestic violence laws. They have to look into the criminal aspect of it, figure out what the maximum sentence could have been for that, what's in the police report, and then decide whether the person is subject to a ground of inadmissibility or if there's a particular exception that might qualify. So definitely don't travel until you get that looked at.
So domestic violence is more serious than DUI based on what you're telling, Emily. So that requires more attention. And what are the probabilities? I mean, assuming that, people are convicted with DUI, that you said probability of them getting the visa, to your experience, is almost 99%. Now, people who have been convicted of domestic violence, what are their probability of getting their visa?
I mean, it could be as low as 5% of getting the visa. It really depends on which specific criminal statute was violated, what the ultimate outcome of the case was, if it was dismissed versus whether the person served jail time or still ongoing. But yeah, there's a very high risk of visa denial in that situation.
Phone number ending with 299. You have any question for us? Phone number ending 299.
Hello?
Yes, go ahead with your question, sir. Yes, go ahead, sir. 299, you have any question for us?
Hello, sir. This is regarding my daughter. She is aging out sometime in March 2025.
Mhm.
And I have AB filed AB2 with the priority date August 2015.
Okay. Emily, what are the options
So
for
I
the
mean,
for the people who are aging out
yeah. What are
and
the
prior to
options,
date
sir?
is August 2015?
Did
Yes,
you have a
yes,
specific
sir.
question on that, or are you just
No,
wanting
what are the
to know
options?
what options there are?
What are the options for her?
Well, assuming that the date is not going to become current before she ages out, the next best option is typically to switch to an F1 student visa. If the person's already studying in college on H4, they need to file that application before they turn 21 with the help of the school getting the necessary I-20 form for that. But you need to look at, does the Child Status Protection Act qualify the person to not age out? And that is looking at what is the priority date? When does the priority date become current? Can we use the final action date chart or the filing date chart? And how long was the I-140 pending? So all of that has to be combined to determine whether Child Status Protection Act will protect her from aging out.
I know we have a lot of callers that are waiting for it. The time is up for us for the TV9. So next week, join us at the same time at TV9. Thank you for tuning us. Thank you, Emily, for coming into the show and answering the question patiently.
Thanks for having me.